We are going to be discussing some cases that have stemmed from the federal court. We're also going to be discussing some cases that either did not reach the federal court or were managed by our firm in form of case studies, to just show you what are the kind of issues that SUV applicants have been facing and how we've been managing them. So I want to, this is a very important matter that we want to begin with, Oroji v Canada. So this was one of the last moment retainers where our firm was engaged only to argue the matter before the federal court. All the pleadings had already been filed, and a very unique situation arose in this case. The principal applicant had obtained a commitment certificate from a designated entity by the name of Karetsu. During the processing of the application, Karetsu withdrew its commitment certificate. The applicant approached another designated entity, Apex, and got another commitment certificate issued. The IRCC sent a procedural fairness letter, a letter to the applicant saying, asking about the change of designated entities and providing an opportunity to respond. The applicant advised that the initial designated entity was investing 75,000. Now they've been engaged by an angel investor who will be investing 200,000 into the business. The IRCC refused the application on the ground that the regulation requires that an application for permanent resident visa must be made within 6 months of issuance of the commitment certificate. This was challenged by the applicant before the court. And if you go on to the next slide, you'll see that we actually vehemently argued, Howard Noman had appeared before the judge and vehemently argued that if you look at the intention of the applicant, if you look at the amount of commitment, the amount of money that the designated entity is willing to invest into the business, this is going to be a successful business. That was the real intention behind the program, to get successful businesses operational in Canada. However, the federal court ruled that it was not unreasonable of the IRCC officer who reviewed the case to opine that the regulation is framed in a manner which does not permit changing designated entities midway through the process. Ultimately, the federal court ruled in favor of the IRCC, setting a very important precedent. That is, once an application for permanent resident visa has been made, after obtaining a commitment certificate, you have to make sure that you stay in regular contact and communication with your original designated entity, and you have to make sure that they do not withdraw their support in any manner, and you see it till the end. Because if they withdraw their support, and even if there's a new designated entity who's investing more money into your business, seeing its potential, even then the application for permanent resident visa may be refused under this program.
I have a comment there, Pushkar. It's an interesting, very interesting case. And I think for anyone listening, you have to always put your entrepreneurial hat and your immigration rules beside each other before you make a decision. Because any entrepreneur who gets an offer down the line to get a VC investment that's more sizable, that may be more supportive, that could allow faster growth, higher uptake, the ability to scale faster, most of us would take it. Right? It's intuitive that you would take that superior investment and the additional funds. But again, here, what I found very interesting when we were having the discussion and making the argument, it was acknowledged by the judge too, where she said, I may not agree with the officer, but I can't say that the officer was unreasonable in reading that provision that within 6 months, once you file the certificate, that is the certificate and no other certificate can supersede it. But what I noticed in the discussion was it wasn't necessarily that she agreed and she said as much, but it was that the officer, when you look strictly at the way the provision was drafted, it was reasonable for that officer to take that view. What will be interesting in these new regulations is to see whether some of these issues that don't make sense from a business perspective, if they're embraced or covered by the regulations. But again, anytime you're going to make a material decision where there's an investment or looking to add someone into your team or potentially remove someone because of a disciplinary issue, Do not do it until you get proper counsel about what the impact is, because this was not intuitive, but strictly reading the law, there was a position that was deemed reasonable. So it was interesting in that sense.
Right. Now, this other case is also very similar to Oroji. Um, in this matter, what transpired is, and these issues are live issues. They are happening in cases that we are seeing before. In fact, a couple of months before this case, and even after this case, we've been speaking with people who are undergoing the same issue. And our advice keeps changing based on the federal court judgments and the policy updates. So you'd find one of this case also along the same lines. There are 5 entrepreneurs who obtained a commitment certificate from an angel investor. All of them were essential members to the business. One of the essential members during the processing, because it had been such a long time during the processing, withdrew the application. The team pivoted and they decided, we don't need the fifth entrepreneur. The four of us can make it work. They went back to the designated entity and they said, please issue a new commitment certificate to us. Mind you, the applications for permanent residence had already been filed and the application was currently being processed. So they got an updated commitment certificate and updated it before the IRCC. The IRCC refused the application on the ground that one of the essential members withdrew their application during the processing. Um, the applicant challenged the case before the federal court, and if you go on to the next slide, you'll see that the council in that case argued that listen, the commitment certificate can be amended. Nothing stops you from amending a commitment certificate during the processing of the case because the regulation is silent on it. The federal court held that the intention behind that regulation, which states that if one or more members who are identified as essential to the business are either refused on the permanent resident visa or withdraw their application for permanent residence, then all the other members of the business will also not succeed in the permanent resident application, and ultimately denied the claim of the applicants, and the applications were refused. This is, you have to keep in mind, if you come together as entrepreneurs, whether you're 2, 3, 4, or up until 5, that's permissible under the regulation. If you're coming together as entrepreneurs, you have to stick together towards until the process, the finalization of the application. Because if you don't, if the application is withdrawn by either any one member who is identified as essential, then you can jeopardize your entire team. And it becomes even more incumbent if considering the fact that the application remains in processing for over 40 months. That's a long period. Personal circumstances, professional circumstances of members, their families may keep changing and evolving over time. So you have to make sure that when you're formulating this team of entrepreneurs, you make a commitment to one another that you will stick it till the end. Because if you don't, then all the applications may end up being refused.
So that's a great point. There are two takeaways there. One is know who your team members are and make sure everyone understands the rules. Unfortunately, we've been engaged by many people midway, and they've already made substantial changes where people have come and gone and new people have made new applications and their different certificates. It's a real mess to unwind. And when you look at the federal court, in many instances, if they apply the precedent, there's very little room to be able to repair the circumstances once those changes are made after the filing of the PR. And the second point is also picking your designated entity. And know that it's like a marriage. You're not able to just swap a new one after, and you shouldn't do that in marriage either. But you shouldn't be just moving over to another designated entity. You have to be understanding that once you file, you're in it with them. So both in picking your team members, it's really important that each person appreciates the consequence of being in a team and what the implications are to one another. And similarly with the designated entity, make sure that you have the support and that their processes, you live with their processes. We're going to talk about that. But even the way that they transmit and they share and save information about your file, everything has to be on par because these are factors that you live with.
Actually, I was reading the comments and I read a very interesting question. It says, if there is a change to the commitment certificate, change of a team member that was made in 2023, will it still be the case that the commitment certificate will be treated as frozen? We'll address these questions, but it stems from the same issue, that these are live issues, and we have to make sure that you, as a client, I think it's very important to make sure that you're consulting with a law firm and advising them about what these changes are and why you're wanting to get these changes made. We've been advising a number of people on such issues, and I think that the changes that you make today, when the application is processed 3 years from now, the impact will be then. So you don't want a situation where you're in Canada working on your business, creating your business for 3 years, and the application is ultimately refused after 3 years. So consult with a lawyer today instead of facing the consequences down the line. Moving on to the next one. This is Buey v. Canada, and a number of other judgments all stem from the same issue with respect to artificial transactions. There is a provision under the Immigration Refugee Protection Regulations, that is 98.12a, that talks about what are the requirements of the program. And there's another provision, 89, that discusses that as an applicant, you have to make sure that you're not applying under this program to gain permanent residency as your intention. Your intention should be to establish the business, and in lieu of that, gain the benefit of permanent residency, and not vice versa. Now, of course, the federal court also rightly puts it. It calls it that there is a very fine line between immigration being motivated in part by the economic motives and participating in the immigration program primarily for the purpose of acquiring status or privilege under the act. And you have to make sure that you stay above that line. That is, your primary intention should always be to establish the business. Now, how do you prove that? You prove that by creating more and more activities of your business, by progressing your business. And Alif has explained, and so Numan has also talked about this. You have to make sure that you keep progressing on your business. You have to keep pushing towards more client meetings, selling your product or selling your service, and keeping a track and record of all of this, so that the officer does not frame that opinion. We can go on to the next one. Another question that I read from one of the participants is that I created my business plan myself, and being not expert in that, it may have some gaps and it's not fancy like consultants make. Uh, we agree with that. I mean, some of them are really fancy. It could be an issue. Yes, I mean, depending upon, we'll have to review your business, and that's why when we start talking about the business plan, it's very important to make sure that the business plan is not just merely an outline and does not just simply throw in what your business is and describes your service, and that's all. It has to be very comprehensive, and the federal court has also recognized this in the case of Ajili v. Canada in 2023. And further from there, we've seen a number of cases that we've been filing, that clients have approached us where their applications are on the verge of being refused on procedural fairness. That we've noticed that there was at times no business plan, not even a pitch deck, and in some instances we've noticed that there is a business plan, but it's like a Word document created by ChatGPT. I think that you must leverage GPT, and you can leverage a lot of different technologies to create the business plan. But the business plan primarily should at least identify the product. It should describe what the service is, what you're trying to create. It should describe the uniqueness and innovation, considering the Startup Business Class program is for unique and innovative ideas under the tech sphere. You have to make sure you identify the revenue stream, what is the cost associated with it, what are your milestones that are going to be in the next 3 to 5 years. So your business plan essentially should be created in a manner which is a pitch that you're giving, elevator pitch that you're giving to an investor who you want them to invest in your business. And if you keep that in mind, if you keep that background in mind with respect to having a very comprehensive business plan, then you should be safe, in effect. But if your business idea, like the federal court puts it, is in effect an idea that was never really fleshed out in the business plan, then it's likely that your application may be refused just on that ground. So you have to keep in mind to make sure that you engage professionals to get a very comprehensive business plan made.
One of the services we provided that's been very welcomed from people who may have filed their application and then realized, and many of you might realize after you hear the discussion, the standard's very high, and there's a lot of requirements that you'll be asked to produce, whether it's through inspection or additional documentation requests, or potentially even if there's concerns at a procedural fairness level, is what we do is a health check, and it's exactly that. We look to see, does the business plan, is it comprehensive? Does it make sense? Are the people in the business, have you described your appropriateness in each one of the roles that you've taken? Have you actually made the case that you have the experience, you're capable? We've seen cases of procedural fairness where the officer just wasn't convinced that a person could execute a role. And some instances, our heart goes out to people who decided that they would do it themselves, and they tried their very best, and they followed the list of documents, and they thought that they did everything, and they assumed that the program was kind of straightforward. If you had a certificate, the language scores, the settlement funds, the shareholdings, well, you complete the form, you file it, and you get your PR. The standard, and that's what today's discussion is about, the integrity and the expectation is to make sure these businesses are real, that they make sense, that they've been selected appropriately, and there's evidence of them being able to perform at a level that would be expected for someone who is truly committed to the business. The good news for anyone who's hearing this and is having a little bit of a heart attack is that we've done this quite regularly. We can go in and we can rebuild, and we can advise and update an application, and then get the clients ready to understand, especially if they didn't fully appreciate what the expectations are, is to counsel them and give them advisory on what the requirements are. And you often can then up your game and deal with those gaps. And then, we've had many people in that situation where by the time we were done and working with them and they really rolled their sleeves up, they were able to get their PR. But if they left their applications in the current state, it was, a problem waiting to happen. So I think it's really important that you do get that second opinion if you're unsure about the quality of your representations.